gentlemen, welcome to Donna Just Being Real. My channel is about dating, love, relationships, and toxic relationship advice channel. Alright, so we're going to get back into Sewer Rat, yes. Sewer Rat, Darrell Brooks trial clips. Entitlement and gaslighting. Now, I did a poll, and I was asking people what they'd like for me to do, recaps of the clips that happened and stuff that happened on the trial. And the poll was saying basically, yeah, they wanted me to do it. And that was, I'm sorry I'm doing it late, but I am doing it. Alright, so I'm going to basically show some clips of the trial. And I want you to watch how he feels that he's entitled. And the gaslighting that he was doing with the jury, with the judge, especially the judge, the prosecution, everybody. So we're going to show a bunch of different clips. And what you do is you share your thoughts and opinions in the comment section and also share the video out. And don't forget to hit the like button. And thank you to all my subscribers, and thank you for the people that has been donating to my channel and sending blessings and stuff. I truly appreciate it. I really do. And we're going to get into this sewer rat again. Alright, because this sewer rat's a piece of crap. Now, look over here. You look at this picture. You see him? Now look at this. Look at the sewer rat. Don't you see the resemblance? Look, really look good. See? See the resemblance? Yep, he definitely is one. Alright, so we're going to get into this one. Alright, so I'm going to show some clips. And there might be some times I might pause and share my thoughts and opinions. Alright? But, let's get ready to show the clips. And I want to start with this first clip because I love this clip when one of the watchers, after he was found guilty, right? I love it. And then one of the people in the back called him a piece of... I love it, I love it, I love it, because he is. So we're going to start off with that clip. And then I'm going to show some other clips and everything of what happened during the trial, his outburst, his entitlement, his gaslighting, all that stuff. So we're just going to basically just watch all the different clips. So don't forget, hit the like button, share your thoughts and opinions in the comment section. And also, if you want to get a hold of me, feel free. You can contact me. Read the description and you'll find my email address. So you can email me if you need of coaching in dating, love, relationships, or if you have a viewer's request. Just let me know. And, we'll go from there. All right. So let's get it, ladies and gentlemen.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Or in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the
Now, this is the famous clip. This was the one when he, after what he did to these people. Yes. After he murdered these people and harmed several. And he comes running to somebody's house and ringing the doorbell. And you remember, everybody, he got that sandwich? That was the last meal, good meal he ever had ever since then. All right, let's watch the clip. Look at, he looked like a sewer rat. Look at him.
Can I called an Uber and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless. I don't know. Yeah. Oh, yeah, for sure. Yeah. That's my ID. My ID. Huh?
3 of the 4 doctors all diagnosed.
Now, ladies and gentlemen, this clip here, this is the one when either the pre-trial hearing, hopefully I have it right, the pre-trial hearing, and when he said he wanted to represent himself. And then the judge basically said, okay, I'm going to let you have it. So let's watch it. She should have known at this time he's going to be a problem. But technically, you have the right to represent yourself. So all he did was represent himself as showing that he's a sore rat and he's a fool and he feels that he's entitled. And all he did was gaslight. But at the end of the day, sir, you looking stupid. And you're in jail for life. You'll never be able to walk the streets again. Resume.
Mr. Brooks with a personality disorder. I'm going to quote at length from one of the reports because I think it's important as I make a determination today that Mr. Brooks is competent to represent himself and waive his right to an attorney.
Quick
I think
objection.
it also, Mr. Brooks, you're not, don't interrupt me. It also helps explain some of the interruptions.
That's a rest
and-
judgment, Your Honor.
Not right now. You can ask when I'm done. It also, I believe,
I
helps.
object.
Mr. Brooks, let me get through this. It's really important that I make a record and honor your request
I understand that.
to
I don't understand
represent
why.
yourself.
I don't understand why.
Mr. Brooks,
um,
I'm going to explain the
something-
relevance. So
I
just
don't-
stop
I don't
talking and listen to
understand-
me.
I don't understand why something pertaining to a plea that is not standing anymore has relevancy to the decision that's being made right now, months
Stop
after.
talking and listen, because you're gonna get the answer. okay?
Okay. I hope so.
Sociopathic people, they never stop talking. Because all they want to do is talk, talk, talk. You're supposed to listen to them because they think they know everybody.
You gotta listen.
Your Honor,
Yes.
I really don't want to interrupt, but while we are still Mr. Brooks's lawyers of record, I would, and I don't know what Your Honor is about to say and read, but I think you said you were about to quote extensively from the reports. It's my understanding that those are confidential unless there's a phase 2 of the trial. And so I don't know if it could be done by allusion, but when I heard you say you were going to quote from them, it did sort of set off warning bells.
I
in
understand.
terms of that.
I understand, and I'm mindful of that. The reports are not made public until a phase 2 proceeding. That does not limit this court from relying upon the information in them in evaluating his request to represent himself in this case.
Is there a case law to back that up?
My decision in this case to frankly honor the request of Mr. Brooks and grant the motion today is based upon the entire record and proceedings and file in this case, including matters that are otherwise sealed to the public, but available to the parties and the court. The bottom line is this, and I can, without quoting verbatim, say this. I did advise the sheriff's department to let Mr. Brooks know, to ask him.
Okay, get ready. Now the clown is about to come out of him. Mr. Sewer Rat, Darrell Brooks. Resume.
On my behalf, if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks,
The reason.
Mr. Brooks.
Okay, now we're watching the trial. This is when the trial has begun. Okay, resume.
I would just want it.
Hold on, I'm gonna mute you for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not
wanted to
asking
correct
for a
it because
response,
it's not-
sir. Mr. Brooks?
It's not. It's
Okay,
not
you're
accurate, Your Honor.
interrupting, hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me. And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
No, I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
No, Surratt doesn't want to change because he feels comfortable with these type of clothing. He's not comfortable in a suit. You know, in a suit that looks professional, you know, he's not that type of person. He's a street guy. He wants to dress like a thug, look like a thug, act like a thug. You know, that's what he wants to be. And he's proud of it. And where did it get you, Surratt? Nowhere but in prison. Resume.
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
I think Mr. Brooks needs his objection.
21.
Did you see any video from the other alleged incident from November 20th?
I'll object. I don't see the relevance to anything that happened on the 20th.
Sustained.
Do you know if there might?
Ladies and gentlemen, aren't you curious? What is he writing? What is he writing? What are you writing? What do you think you're going to prove, Sorat? You're not proving anything. You just look like a darn fool sitting there. You know, that's it. But you see, with sociopaths, they want to have the last word. You know what I mean? And he basically knew that he wasn't going to win. He knew this. It wasn't possible. He was going to win. But he decided he's going to go out with a bang. This is how these sociopaths think. He wanted to have the last word. His whole goal was to try to make the judge look like a fool. He wanted to make the prosecution look like a fool and the jury. That's what they do, because they have a sick, twisted mind. But at the end, it didn't work, did it? You had your little show. Yes, you did. I have to admit you did. Reason.
Might have been any video from the alleged incident on November 20th.
Same objection.
Sustained.
Grounds.
It's not relevant.
May I ask how is it not
Next
relevant?
question. There's not a charge related to the 20th, sir. It's not relevant. I've given you leeway to ask questions at this point under 90611. Move on.
Just so I'm clear, you have never had any interaction with the plaintiff.
Objection.
Sustained.
You've never seen the plaintiff.
Objection.
Sustained.
Never spoken to the plaintiff.
Objection.
Sustained. Move on.
Just so I'm clear, you have never had any interaction with the plaintiff.
Objection.
Sustained.
You've never seen the plaintiff.
Objection.
Sustained.
Never spoken to the plaintiff.
Objection.
Sustained.
Never seen. Do you see the plaintiff in court today?
Objection.
Sustained.
Do you know if there is a plaintiff in this matter?
Objection.
Sustained.
Have you had any prior knowledge of the plaintiff in this matter?
Objection.
Sustained.
Would it be fair to say that you do not know of any plaintiff in this matter?
Objection.
Sustained.
On grounds? What grounds?
Under 90611, I'm declaring the cross-examination now closed. Do you have any redirect for this witness?
Briefly, Your Honor.
Thank you.
Detective, when you reported that Erica Patterson had been less than completely forthright with you, what did she leave out the first time you spoke with her?
She left out the incident that happened to her on November 21st, 2021.
The incident where she accused Mr. Brooks of punching her?
Correct.
Okay. You testified on cross-examination that in your general experience, victims of domestic violence do not report 100% of the details all the time.
Objection. Hearsay.
Overruled.
Grounds.
He hasn't asked a question yet.
Grounds for the.
He can ask his question. This witness testified about his experience based on a question you asked, so the redirect is appropriate.
May I just say that every situation is different, Your Honor? Which we
You're
do know
attempting to
that.
testify, so no, you may not say that. The jury will strike that comment made by Mr. Brooks. You'll have an opportunity, if you so choose, to testify at a later point in time in this trial. The state may ask its question.
Thank you. Did Erica Patterson provide to you a specific reason for her situation, why she was not 100% forthright with you?
Yes.
What was that reason?
She was.
That day, were you with anyone else besides those two that you just named?
Mr. Brooks, you.
What about
He has Erica on the stand. This is a form of gaslighting with the silly, stupid questions. What a shame. Reason. You know, this is what happens when you're in relationships with sociopath and narcissists. All they do is want to gaslight you all the time, manipulate you, You know, they just don't give up. This is what they do. They only come into your life to use and abuse you. And he got her at a young age. And I really feel sorry for her. And I feel not just for her, for so many other women out here that's going through the same thing. And even men too, because men, you know, get abused by women too. They get manipulated, used, and abused. You know, like I said and I've said a million times, if anybody has been watching my videos, and if you haven't, you know, check out some of my past videos. I always say these narcissists and sociopaths and psychopaths, the whole cluster B personality disorders, toxic people, I feel that they work for the devil. They are devil's helpers. That's what they are. And he is a form of a devil helper. Resume.
Alleged incident on the 20th.
I left with Miss Corey, and then she went a whole different direction, and I went to Frame Park and met up with Mr. Brooks.
And as you watch this video, you can tell she's still traumatized. She's still scared of this man. You know, all these years of grooming and manipulation of what he has done to her. She's still terrified. I could tell by seeing her looking on that stand. I mean, these are all my thoughts and opinions. I don't know her. I haven't, you know, hung out with her and talked to her. I'm just going by my knowledge and, you know, experience and my research and my, you know, I've been, you know, did a lot of research on these things and then got certification, you know, for a coaching. And what I know of, I can look at her. She's scared. She is. Even though she knows he's there, he can never touch her. But so much abuse for so many years, this is what happens. And it's sad. It really is sad. Okay, let's get back to it.
Just want to say,
I know I keep pausing. If I could say anything to Erica Patterson, you are a beautiful woman. And I just, you know, I just hope that you're getting some really good therapy because you've been through a lot. And I mean a therapist who specializes basically in narcissist abuse. Because, you know, who's deal with narcissist abuse, trauma bond, gaslighting, all of that. That's what you need. And to so many other people too out here that's been through it. And I've been through it myself, so I'm not just talking stuff like I haven't been through it. I've been through it myself. And I can understand and relate to what she's going through. And just to be careful who you keep around you. Because a lot of people will, you know, they look at you as kind of like, what can I say? They look at you kind of like you were a celebrity. You was on the trial with, you know, with Surat and, they'll try to use and abuse you. And you're kind of vulnerable right now. This is all my thoughts and opinions, everybody. I don't know. I haven't hung with. I'm just going by my past experience, what I know of in my coaching, because I've been coaching for a long time with narcissist abuse, dating, relationships, such and such. So just be careful of the people that come around you because they'll be narcissists and sociopath too. And they'll come into your life and act so charming and sweet. And you'll be thinking, oh, this is a good person, but they're not. And I'm going to do a video on that one. Because like I said, it's like, be careful when you go into another relationship, ladies and gentlemen. And if you've been through a very traumatic relationship, be careful who you tell that new person. Because that person could be a snake in the grass, just like the person he was before. And they'll listen to it. They'll say, oh, they've been through this? Oh, okay. So they're vulnerable. I'm going to see if I can do the same thing. I know it sounds sick and twisted. And I'll do a video on that one and break it down to be careful. And I just hope that she's getting some good therapy. Keep a journal. Write everything that you went through in this relationship with this man. And write a book. Yes, I said write a book and put it out there. Because that book will be healing to you. And would also help other people. And it would show this little This sewer rat of a person. Yeah, him. It would show sewer rat. Look at him. Look just like a sewer rat. Show sewer rat that, hey, I made it. I'm good. You might have tried to destroy me, but you can't. I'm strong and I'm powerful, and I'm going to live my life the way I want to live my life. Exactly. And that would be, ooh, that would just kill him. And like I said, the book would help other people too. But just be careful of the people that come around you. And who do you go to? You know, let's say, writing the book and everything. Have the right people that's supportive. Okay, I know I just talked a lot right now. But I want to share that just in case that she happened to be watching this. Hopefully it's helpful, these words. Because, I care about her and I care about a lot of other women that's going through the same thing. And even men too. Because believe it or not, I have more male clients than I have female clients. Resume.
Recollection, you were not drinking both of those days that you cite, the 20th or the 21st.
The 20.
Hold on. Mr. Brooks, under 90611, I'm stopping this cross-examination. You've asked the same question, multiple questions, multiple times, and at this point, I'm going to declare that the opportunity to cross is now concluded.
I didn't know that was the same question, Your Honor.
Mr. Brooks, it's been asked and answered multiple times. So with that, I'm going to turn to the state to see if they have any redirect.
Some brief clarification.
Go ahead.
And what I like about with the judge, how she handled that, because she could see it herself. She could see that this woman is scared for her life right now. Even though the man is back there and he can't get to her. But the judge knows. Shout out to the judge. You're a beautiful woman. She sees it. She sees it. Resume.
Thank you. Ms. Patterson, after the parade incident, which took place after the video we saw, right?
Yes.
Okay.
All right, we are back on the record. Appearances are as they were before. I need to make a...
Okay. This is the clown taking off his shirt. These narcissists and sociopaths, they act like children. They basically children. They little toddlers that never grew up. It's all about me, 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 me. I want this, I want this, I want attention. Listen to me, blah, 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 blah. And this is what he's doing. He's having a tantrum. He's having a tantrum. Let's get it.
The record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting. That at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear.
See, with sociopaths, they don't like to follow rules, especially the law. He can hear everything clearly. He's just giving a hard time. That's what they do. They just love to give a hard time. And let's say, for example, if you're driving, the speed limit is 50, correct? A sociopath is going to want to do 70. They don't like the fact that you tell them you can't just do 50. They want to do 70. Whatever you tell them to do, they want to do something opposite. And he can hear it very clearly in there. Technology is awesome. He can hear, but he's just going to act like he don't. This is what they do. They have selective memory, what they want to remember or not. Full of crap. All right, let's get back to it.
The court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera, since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the.
Look at him, just talking and complaining with the hand movements. Piece of crap. He really is. He's 100% a sewer rat in the gutter. Let's get back to it.
Appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous.
You know what I would like to do? I would like to ask his first grade and kindergarten and first grade teacher, what was he like? I know he was a handful. I know he was. Because it starts showing around that age. Around kindergarten, first grade, second grade, there's signs to start showing. But it really shows a lot in high school. Definitely in high school. But his mother, what we see right here, where is he? Where is the mama? Mama and grandma was enablers. You knew he was a problem when he was up in high school. You seen the signs. But you wanted to sweep out the rug and say it's all because of bipolar. You know, no offense, I'm not saying with bipolar, excuse me everybody, so please don't think I'm saying offense, but there's a lot of people that suffer with bipolar, but they don't act like this. No. So don't put it on the bipolar people. I don't appreciate that. You know, no, it's not like that. Resume.
Hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the...
You see him putting up his hand? The poor me. I'm injured. Okay, but what about the 6 people that you killed? They don't care. Sociopaths don't have no remorse, no empathy. They don't care. It's all about him. He don't care about these people at all. He don't care about them. He don't care about the people that he wounded. No, he don't care. He don't care the fact that there's some people that, has been hurt. And as we speaking right now, they are in a lot of pain, trying to figure out how they're going to pay the hospital bills, get the medication, be able to pay for the medication, pay for physical therapy. It's a lot to it. But no, he doesn't care because it's about him. Let's get back to it.
Preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m.
Jail cell. Yes, ma'am, to the best of my knowledge.
Okay.
Is he still
object
able?
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity. Your objection is overruled.
Will she be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I am turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object just like she objected when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms. Molenhop,
that you are making.
while on COVID protocol, Does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses, is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials, is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether
He's objecting because basically, because he's been lying. He know he has access, but he just want to prolong it. He just want to be difficult. This is what sociopaths do. They don't want to make things easy. Like I said, they do not follow the rules. They don't like the fact when someone tells them to do something. They're very defiant. They don't like that. That's why they say they have problems in school. They have problems with the law. They have problems with police officers, principals, employers, supervisors, stuff like that. They always have a problem. They will always be combative. Always. This is what they do. That's why I say with your children, you have to watch them when they're young. You can find out these signs. If your child might be a narcissist or a sociopath, and pray to God they're not. But in some cases they are. Some kids are just born evil. I hate to say it. You didn't do anything wrong as a parent. Mommy and dad didn't do nothing wrong. They just outright evil. Let's get back to it. Resume.
there's lots of rules of evidence that apply, but if you're objecting to her answer, that's a different thing. You can argue the meaning of that language. Okay, the objection, but then you have to say objection before she answers. You objected after she answered.
She didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail, correct?
I respectfully object to that.
Overruled, she may answer.
Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am.
And
So you're gonna
the
overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has the
don't see
rules
it.
of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that.
See, this is what I'm talking about. They want to be difficult. The judge, she follows the rules. She made sure, because she could tell that he's one of those, one of those little smart butts. She have it there. He's just like, no, I don't see it. This is what they do. They lie. Once these narcissists and sociopaths open their mouth, nothing but lies come out. But he think he's going to manipulate the judge. He think he can, gaslight her. Right now, he's trying to gaslight her like, I don't know what you're talking about. Yep, really. Surat is just not working. That's why you in prison. I don't know if you got there yet, but you're going to prison. Resume.
Available to you.
Anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
them
may
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity for Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack
don't
of
give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
You see how she walked out? And he just won't shut up. This is what they do. They won't shut up. They'll just keep talking. I think that's the end. Let me see. And fast forward.
Do you remember what you can recall?
Do I remember if I can recall?
Do you remember the disturbance you recall?
Yes, I do.
Would you state what that is? What that was, rather?
I heard a horn beeping, and then a Ford Escape came through the parade route, and you drove past me and wouldn't stop, and you continued driving into the parade route.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name.
Your objection is noted.
So, you heard a horn beeping.
Yes.
Was it coming from the vehicle that you tried to stop?
I believe that it was.
You stated that you've been in law enforcement for 25 years. That's a long time. So it would be fair to say that you operate a motor vehicle pretty much every day. Would that be fair to say?
Yes, I operate a motor vehicle almost every day.
And would it be also fair to say that you would only beep your horn in a motor vehicle if you were trying to alert someone to your presence?
I think that could be a fair statement.
Would it be also fair that you would beep your horn to avoid any danger?
There could be many reasons why a person is beeping their horn.
Would one of those reasons be to avoid danger?
It could be, yes.
Do you recall if you were able to see who was operating the vehicle you attempted to stop?
Yes, I was.
And can you recall a description of the operator of the vehicle you attempted to stop?
He was light-skinned, black male. He had some light facial hair.
Is that all you recall?
That is what I recall.
Do you recall what they were wearing?
No, I do not.
So you were able to get a description of how the operator of the vehicle looked, but not what they were wearing?
That is correct.
Do you recall how fast the vehicle was going at the time you attempted to stop it?
I believe the vehicle was going about 3 to 5 miles an hour when I tried to stop the vehicle, and it continued on past me.
Would it be fair to say that 3 to 5 miles an hour is not very fast?
I think it's very fast when you're in a parade route, when there's hundreds of people marching in the road, and a police officer is standing in front of your car, pounding on the hood, trying to get the vehicle to stop. I'd say that that's too fast. Any speed.
Right at this moment, Surratt is trying to gaslight Detective Burns. They just don't give up. They really don't. Resume.
It is too fast on a parade route when you have all those people in the roadway. A car should not have been there.
That wasn't the question, but thanks for the commentary.
Detective Casey, please just answer his questions. Attorney Opper will have an opportunity to redirect if necessary.
Would it be fair to say that that's not a very fast speed?
Objection, asked and answered.
Sustained.
Did Mr. Brooks say anything to you or Erica or Nick as he was leaving?
He told Erica he was, oh,
The basis for your objection, you said objection, right?
Is hearsay and irrelevant.
Is it being offered for the truth of the matter asserted? From the
Well, it's
state?
a statement by a party opponent, so it's not hearsay.
Oh, it's his statement, sorry. I think I misheard what she said. All right. The objection is overruled. If it's, she may testify as to words that you spoke on this occasion. Go ahead.
he told Erica that he was gonna find her and he's gonna kill her.
Can we pull up Exhibit 5 for the witness, please?
This is ridiculous, man. Soon as I raise the issue, I'm being disruptive. I'm intentionally trying to be disruptive. I'm intentionally doing this. I'm intentionally doing that. So I should have just stayed over here, which ain't even legal to do anyway. Can't be present and not present when it should be a motion. This is ridiculous, man. This is ridiculous.
Okay.
You're forcing somebody to agree to something that they ain't agree to. Y'all come up with anything y'all can. Anything y'all can, huh? Why I need that in here? You could have left that over there. I'm going back over there anyway.
Just in case.
If I'm right here in front of the face, I ain't gonna have no problem hearing. That's why these could have. I'm gonna have to go back over there. Y'all know that.
We'll bring it with us.
I'm just saying, man, this is ridiculous, man. This is ridiculous.
Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, State of Wisconsin plaintiff, that's an entity. You have to name a person, sir. The date. Well, the date we would fill in. So I'll have it shown to the state and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity, it's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, Based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due
Sir, I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir,
So
based
you're
on
making-
law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or
I'm
fact?
going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges. And without...
Mr. Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced?
Here we go with the entitlement. Let's get back to it.
It states under the Sixth Amendment that I have the
Sir,
right.
I've already addressed this. Okay? We're not going to have any further argument on this topic. All right? Your Sixth Amendment rights are being honored no differently than any other defendant.
Surat, you killed 6 people. You injured several people. I can't remember the amount. And there's so many people that they might not have got hurt or anything, but they seen the stuff that happened and they're going through PTSD. So they mentally messed up. And it was a holiday time. They'll never be able to enjoy the holidays like they used to. And you worrying about yourself? See, this is what I'm talking about, ladies and gentlemen. They don't care about nobody but themselves. It's all about them. He figures what happened, like, oh, well, whatever. They died. Everybody, let's just move on. Get over it. You know, tomorrow's another day. No, it doesn't work that way. 6 people died, and they have family members that are grieving as we're speaking, and probably will never be able to get over it. And you don't have to get over it. It's understandable. You lost someone that you love. This was a child right here. Look at this child right here. A child. You know, never got to go to his high school prom, first girlfriend. You know, parents were able to see him get married and they have grandchildren. No, it was all taken away from them because of Surat. Yep. Let's get back to it.
That has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor. A
Sir,
living...
it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've direct your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to
I'm
you,
not.
sir.
I'm just asking what kind of case it was. Was it federal Supreme Court
It's a Seventh
case?
Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. So, but you're citing a court of
No, but
appeals
Court of
case.
Appeals case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I'm not going to explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely stating for the record.
Yeah, I heard the door. Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my accuser.
Your objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses that testified are the accuser. None of the witnesses that testified are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'll say on that.
I'm not confusing any law. The Constitution says that I have the right to face my accuser. And under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is an issue that needs
Your
to be
objection is
raised.
noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of
Your
Wisconsin,
position
the plaintiff.
is noted, sir.
Is
It's
that a
noted for the
judicial?
record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself.
Is that a judicial determination?
All right, I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor, or is
No.
that a tacit agreement?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
I'm not sure what the terminology for that is, but that's how I would take it. That's a subpoena.
No, that's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you
Get all low to him like he's some sort of professional lawyer and he's breaking things down. I'm telling you, these sociopaths wear so many masks. They clowns. They entertainers. He basically turned the courtroom into a circus. That was it. That was it. That was his whole goal. But at the end, he lost. Let's get back to it. Resume.
need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
Something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions
Yes,
for this
I do.
witness?
Yes,
Please
I
ask
do.
them. Would like to get through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that it's
why
frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to a estoppel. Can you prove?
All right, thank you. The jury can come on out.
So we're not going to address this civil matter?
No.
I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
I'm
can
not
I bring
addressing
it up
it.
with the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr.
civil
Brooks, the
case.
jury's coming out. I'm not
If
going to
it's-
address your request
if
for
it's
open
civil-
records.
if it's civil,
I'm not
then
the
it needs to
custodian
be
of the records,
who's being
sir.
sued. My Cestui Trust is being sued? Civil is a
Mr.
civil
Brooks, this
matter.
is an irrelevant matter that you're attempting to bring up in the presence
If it
of the
was-
jury. The
I
record
was
should
not. I was
reflect
trying
these
to bring it up
interruptions.
before the jury came out, Your Honor.
And I
know
told
that.
you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My Cestui Trust? Because how can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter between you and the
It
clerk of
wasn't,
court.
it wasn't irrelevant
So-
when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So I'm
disregard
being
these
sued?
irrelevant
This is a civil
comments.
matter? We haven't addressed subject
All
matter
right, thank you,
jurisdiction yet at all
everyone.
either?
Please be seated. The jury
So
will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
Yes. No,
All right,
they're not.
and
Just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case.
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant
I have
matter.
the
I'm
paperwork
starting
sent
the
by the clerk
trial.
of courts right here that says it's a civil matter.
Mr. Brooks
So
has
what's being
nothing to
sued?
do with
My
this
Cestui
case.
Trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going to
do you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. I'll rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna. This is.
You are
I
not
was
being
given
respectful
this
to this
paperwork by you, Your
proceeding
Honor,
or to
with
this
all
jury.
respect.
No,
With
it's
all
not.
due
With all due
respect,
respect,
with all due
stating that doesn't
respect,
make it
I was given
respectful.
this paperwork by you,
Mr.
from
Brooks,
Monica Paz.
stop talking
the
till the
clerk of
jury
court.
is out.
Okay,
Thank you.
so why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it,
That
bottom
was the
line.
time to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please
I was
be
trying to
seated.
simply address paperwork that was given to me by you, Your Honor. That states that
Mr.
this-
Brooks,
it states that
you
this
have
is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom. I don't want to
On-
do
on
that.
what-
I want you to stay here.
on what
But
fact of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court.
can't
But
charge
from
me.
now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the records. They will simply have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up. All right, it is irrelevant.
It needed to be noted for the record.
It doesn't
Because
need
it
to be
was-
noted, sir.
You
All right,
gave
the
it to
jury's
me-
coming
you gave
back
it to
out,
me
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that.
Did you
Your Honor.
hear what I said,
No,
sir?
I did not. I object to that, Your Honor.
Well, you can
And-
object, and your objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none of
Your
that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
with proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off, and when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm
out,
not angry at all.
and then we will
I just wanted
continue.
to. I don't.
Be seated. Mr. Brooks, before I have you question this witness any further, it sounds like to me that you are attempting to offer through this witness the statements made by Mr. Lascano. If that is what you are trying to do, you may not do that. You will have to call Mr. Lascano as a witness if you so choose, if he's on your witness list. But that your questions are seeking to elicit hearsay from this witness. That's why I had the jury removed so I could explain my ruling and why I'm going to direct you not to ask this witness questions about what Mr. Lascano may or may not have said.
I'm reading directly from his report.
That would be double hearsay then, because it's not you need Mr. Lascano here to say what he told this officer. If you are attempting to offer it for the truth of the matter asserted, which is what I believe you are doing, you're attempting to establish the veracity of something Mr. Lascano either said or didn't say through another witness. That is hearsay.
So it's not hearsay for the prosecutor to bring up.
I'm not going to talk about other rulings. There's been an objection by the state, and I'm sustaining the objection, and I'm directing you not to ask this witness questions that would call for this witness to say what Mr. Lascano said. That is hearsay. That is textbook hearsay, Mr. Brooks.
Then I don't think it's fair for me to object to hearsay from the prosecution along the lines of the same type
Yeah,
of thing.
I'm not going to have a debate on what may have come in previously. I know you've made a number of hearsay objections, many of which the answers that were being provided were not hearsay. But I would direct your attention to 908.01 of the Wisconsin statutes. You have that book in front of you that I provided to you a number of days ago at the beginning of this trial or near the beginning of this trial. There's the definitional section of the statutes, which defines hearsay. It also, and then if you go on to 908.
I know what hearsay is.
0.02, that's obviously one you may want to look at as well. And then 90803 has the exception. So unless you can give me an exception, sir, as to why this witness should be allowed to answer those questions, I'm gonna, again, direct you not to ask
directly
these
from
questions.
his report, the report that he wrote. Nothing is coming from. I'm reading directly from his report. That's what I have in
Doesn't
front
change
of
the
me.
fact that it's hearsay.
You said what?
That doesn't change the fact that it's hearsay.
So
It
his
actually
report
creates
is
another
hearsay?
level of hearsay. It's an out-of-court statement.
So
Not
his-
this witness made, but what another witness made. So you have to,
So I can't read from his report that he wrote.
you can't ask this witness questions that call for a hearsay answer.
Right now, Surratt is attempting to gaslight her. This is what they do. Very argumentative, combative. you know, to get you stirred up, to get you riled up, and then at the end they want you so you can look like you're the crazy one. This is what they do. It's all a manipulation mind game. Resume.
Answer unless there's no objection from the state. Or you can convince me there's an exception to the hearsay rule that applies. Do you have an exception you'd like to offer to the court?
So I might as well not read the report that he wrote then if I can't question him about the report that he wrote.
That's your misunderstanding, sir, what is hearsay. And all I can tell you is I'm sustaining the objection. I'm going to bring the jury back out, and we'll go from there. All right, Madam Clerk, bring the jury out, please.
Clear bias. Clear bias.
Mr. Brooks, I understand you may disagree with
or agree to
the...
being called that name. For the record, again, I'm here as a third-party intervener on behalf of my client. I don't know why that's not understood by now. So I guess I can't bring up the plaintiff either, huh? Tacit agreement.
All rise.
Thank you, everyone. Please be seated. Continue with your questions, sir.
I gotta tread lightly.
The jury will disregard that last comment.
Correct something.
You're saying it goes to bias. How does it go to bias of this witness, sir?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
Okay, well, I don't know how you want me to answer
How
that.
would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I would recall the witness if I
I'm well aware
determine.
what an offer of proof is.
Okay,
I'm well aware.
so make your offer of proof.
I don't need to. It's clear. It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument. You're telling me that it's clear.
I wasn't referring that to you. The person that was referred to know who they are.
Well, let's stay on task, please. So
I'm trying to.
You're claiming it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask.
Mr. Brooks,
but then when I
had an objection before. Well, here's the thing: you want to go off target, and you want to bring up things from the past. I can't explain to you why sometimes the state has an objection and other times they don't. But when when an objection has been made, it is my obligation to rule on it. And so there was an objection.
I'm aware of that, Your Honor. But I'm also aware of the fact, and it's clear that I object quite often, and every single time I object is just thrown to the side every single time.
Well, I would disagree with that characterization, sir. And I make my rulings in this case
based. Why would you disagree with that?
I'm like an umpire.
Point out one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them. That is my role, and that is what I do. And
are you kidding me?
That's exactly what I do. I'm an umpire, sir. I am a referee in this trial.
If you're the
and let me finish. Okay. Let me finish, Mr. Brooks.
I apologize. I'm letting you finish.
Sometimes parties make objections, sometimes they don't. There can be a variety of reasons. You make a lot of objections in this case. From my perspective, okay, you make a number of objections, I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence. So for example, if there's a relevance objection, I'm going to analyze that, okay, based on the objection that's been made. Sometimes I might think there's another basis for something to either come in or not come in. But my rule book, okay, is the rules of evidence, which are the statutes, which once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine. But you cannot then claim that there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance of the law is not a defense for any of this. Okay, and you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. And I've asked you repeatedly for an offer of proof. You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias, for which I will allow him to answer that. You haven't given me a legal or factual reason to overrule the objection and to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, but I recognize it's 3:25. It will be a good opportunity for a comfort break. And when we come back on, the state should be prepared to call the next witness.
Can I at least rebuttal to what you just said since you asked me not to?
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not about agreeing.
record.
You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record a rebuttal.
What would you like to put on the record as it relates to the specific issue for which I was giving you the opportunity to be heard? Not anything else, not subject matter jurisdiction, not
now you
whether
said
the
that.
state's doing
I
other
didn't even bring
things.
that
I'm
up, Your Honor.
only asking you to address the offer of proof.
No,
if
I
you
wanna-
have something, go ahead.
I wanna-
Only as it relates to
I want to
that.
address your position because you said you're like the umpire, right?
Well, I'm not getting, okay, go ahead, sir. I'm not sure why you need to respond to
Because-
that.
Because it needs to be on the record. If you're the umpire, that means you're the referee.
That's what I'm doing here
when-
today, sir.
And when you're not reffing fair if the jury's not allowed to hear things that's important for them to know.
I respectfully disagree, sir. Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't question
make it
anybody
so.
about that.
Okay?
That was
it doesn't make
between
it
you
so.
and I. That didn't have nothing to do with a witness. I've
You
never
wanna
once
question
questioned a
these
witness about
witnesses,
subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I am not going to explain that because I don't have to
You can't
explain
say
that.
what's my reason for asking it.
Well, I believe you've made it very clear, sir. So here's the bottom line.
I don't.
One of my roles is to be the umpire.
Then you got to
All
be
right?
fair, Your Honor. You're a public servant.
I am fair, and I'm
No,
going
you're
to follow
not.
the
You're not
rules
being
of
fair.
evidence,
Your
sir.
Honor,
That
this is
doesn't
why I say
mean
that.
unfettered questioning
This is
of
why I say that.
witnesses that are not relevant or that call for hearsay or for a variety of other reasons that are speculative. There's a whole host of reasons in the rules of evidence, sir, that require me to make those determinations.
You're not being
I
fair.
respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree with the characterization. I think it has more to do with your lack of understanding of the rules of evidence and the rules of procedure, which you knowingly and freely and voluntarily and deliberately made a choice to represent yourself. And
And you keep
I
saying
warned
that
you at
because
that
it sounds
time,
good
sir.
on the
You did
record,
that
but
at
it's
your
not.
peril.
It's not accurate. You accepted when you gave me the paperwork, Your Honor.
I gave it back to
I'm
you.
not going in, I didn't say that, sir, so we can go back and rehash all of those things.
But you know you accepted
Alright.
the way that I gave you the paperwork back. So once
And
you
I made
accept
findings
that,
on the record, which I will stand by, sir. So
and I'm not,
with that,
I'm not
we're gonna
arguing,
take,
I'm
we're
not
gonna take a
arguing your
break.
findings.
I
I'm
need a
not
comfort
arguing
break.
the findings,
I'm sure
Your Honor.
you need a comfort. I would like to get through one more
You gotta,
witness today.
you gotta,
Thank
you gotta
You're
call
off
it
the
fair.
record, sir.
You got.
Okay. Thank you, sir. I don't have any other questions.
All right, sir. Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record. Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who's you?
Well, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd have to be standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds?
irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the sustain.
If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused for the evening. We'll see you tomorrow morning. All rise for the jurors, please.
It was broken.
Objection, pleading speculative.
Overruled as to both. The witness may answer.
Sí. Yes.
And you had torn ligaments.
Objection, leading.
Overruled.
You say that in the question before?
Sí. Yes.
And were those both in the same leg?
Objection, leading.
Sí.
Sorry,
Yes.
overruled. If we
Of course.
just wait when there's an objection. I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
Judicial misconduct at its finest.
And which leg was that, sir?
Objection, asked and answered.
Overruled. You may answer.
El pie izquierdo. My left leg.
Did you have to have surgery on that leg?
Objection, leading.
Overruled.
Sí.
Let's
Yes.
see what y'all
Just one?
trying to get.
Dos. Two.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want.
You
to say.
called this witness. I'm going to take a break right now and excuse the jury and this witness. All right.
What you doing is judicial misconduct. Judicial misconduct. But you don't want the jury to hear the truth. That's not fair to the jury. They have a right to hear everything. Not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Mr. Brooks, please stop.
No, there ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please, nigga.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there. Man, quit it. You supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be
Okay,
present
and
in this
under what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
but the fourth option that you made up, that's not even in the law,
Mr.
because you
Brooks,
can't do that.
I need to make a
By law, you
ruling.
can't do that,
I need to
and
make
you
a
know you
finding.
can't.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom. Please make sure he has his objection signed and a pad of paper.
So is that
he can.
so is that holding me in
meaningfully
contempt?
participate, and I will make a ruling when I.
So are
after
you
we
holding
come
me in
back up.
contempt? Is that civil or criminal?
I'm not saying you're a demon. No, not you. Not y'all saying that. But it's just I feel that way because
We're just trying to just.
I know you heard that. Oh my God. Oh, that fucking hurt.
Sure.
I know you heard that.
I heard it. It's in check.
We're gonna go check with them. Maybe they'll listen to us a little bit better.
Fuck.
You want us to check?
Yeah. Oh my God.
Yeah, give us a minute. See what we got.
Dude, it gotta be something wrong, man. How in the hell does it?
Sometimes sprains will pop too.
Yeah, but why is it hurting like this? And they say there's nothing.
Because
Dude.
sprains can actually be more painful than a break.
whatever they did, it hurt so bad.
You want to keep the food? Why don't you keep the food and the soda, and we'll be back in a few minutes.
You see how sociopaths lie and they really sneaky? He's talking about, oh, I'm in pain. Listen to that. And they walk out and he's sneaking around looking at the paperwork. This is what they do. Just like a kid. Isn't that what kids do? That's why I say narcissists, sociopath, they never grow up. It's just like a kid. It's a toddler, a full-grown toddler. Look at him. He ain't think he's slick. Like there's not cameras in the room. Like these detectives didn't step out and deliberately set him up like this. Really? Really, dude? Sewer rat? Really? Let's get back to it.
Yeah. I think we got that tile off. We'll be right with you.
And the clip ended at 2:05:45.
So is that standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as...
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
One last time, Mr. Brooks, do you have a position on the state's
Can I go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully,
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document that was
Reference to
accepted for value and
the-
returned for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
let me know when you're finished reviewing it, and
I don't have to review the same document that was reviewed yesterday, accepted the value and return for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you made.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself.
I'm going to caution you, sir.
Do you understand what I was saying?
During multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir, you say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's
you're making an incorrect record.
It's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling disrespected?
Mr. Brooks, I'm not going to engage in this
I don't think
back
he did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah,
number
but your
two,
observations are incorrect.
It's my job to ensure that under 906.11, that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to read
906.
it. Just make sure that you make a correct
The judge shall exercise
record.
reasonable
Don't lie on the
control over the mode and order of interrogating witnesses and presenting evidence
gonna
as
get
to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr. Brooks' objections, his response was, stop trying to be slick.
Yeah, I did say that.
So, just for the record, I thought that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the return?
When we come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard
Because
not to highlight
that's the
your
definition of
misconduct
trying to be slick.
during the trial. I'm trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and
But all right, we're in
refer
recess.
to what
Thank you.
conduct
It's
you're referring
3:14.
to. If you're gonna be biased, then somebody else.
All right, Mr. Johnson, 67 you testified was an overview photograph?
Yeah, that's an overall photograph of the.
Overruled, they're now being shown to the jury. It's proper, it's foundational as well. Go ahead.
Yes, this is a overall photograph showing the location of the vehicle, but specifically also showing the front end damage of the vehicle.
All right. Next, 93. Please describe.
A close-up.
Overruled, go ahead.
A close-up of the damage that has been sustained on the front hood area, bumper area of the red Ford Escape.
Next is 68.
Objection.
Overruled.
Mid-range photograph showing the damage, front-end damage, specifically from a reference point of the front passenger corner of the vehicle.
I observe on the bottom of that photograph there appears to be some liquid substance on the ground. Do you see that, sir?
Yes, I
Objection
do.
leading.
Overruled, foundational. The witness may answer.
Do you remember seeing that substance that night?
Yes.
Were you able to tell what it was?
Objection speculative.
Overruled, based upon his training and experience, he may answer.
Not specifically what type of fluid it is, but some kind of engine compartment fluid.
From this vehicle?
Yes.
Okay. Number 102, please.
A mid-range of the driver front quarter panel, also showing what I describe as a white headband on the broken driver door mirror.
Is that illuminated in some fashion?
Objection
Yes.
leading.
Overruled, the witness may answer. Just a reminder to wait until I fully rule on the objection before you answer.
I apologize. Yes.
How was it illuminated?
Objection leading.
Overruled.
It has white LEDs that are within the cloth and they're blinking on and off.
Okay. And then last would be 103.
Objection.
Please describe. Oh, I'm sorry, he objected.
Overruled. Go ahead.
An overall from the further into the driveway showing the back end, the rear end of the red Ford Escape.
All right.
Can't keep doing stuff without. It should be a fair trial. That's my right. Shouldn't be able to do things without my knowledge. And pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being
documents
called that
are
name.
being put on the
I don't consent to being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do not
I'm
interrupt me, or you will
I'm not
forfeit your
entitled
right
to
to be
know how I got
present
there.
in this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're gonna clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right. No, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit anything.
I'm going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35, at 3:06, there was a hilarious comment, at 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
And I'm not stopping you from
Through your
doing that.
behavior, you're not going to delay these proceedings today.
I'm not trying to
We're
delay
gonna
the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to
bringing
do.
the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating
You're
facts.
raising your voice. It's
Because
very
I'm
angry tone,
tired of you
and
always
it's
making a
yelling
record.
at me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately
You're
being
making
done
a
in my
record of
courtroom.
incorrect statements. That's what you're doing. You're not making a record of
Mr.
not
Brooks,
being
I'm
able.
advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be
I'm
quiet?
advising you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you lower
we're all
your tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to do
sir.
anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we have 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about,
There's a reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's
exhibit.
been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No.
But
What I've
for
observed
her,
is
for her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know
Her
what you're
laughing
saying.
under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with
noticed that other than the one thing you pointed out.
Well, we
today,
have
that-
cameras. That's what the
Mr.
cameras are
Brooks,
for.
let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take that
and
as.
do you have
I
anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record
As
if I
it
get a
re-
chance.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not. She just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of
need
any.
legal basis for when she just admitted on the record that she just made this exhibit up?
Combative. This is how they are. They forever want to argue with you and argue with you. They think they smarter than you, but they're not. Let's get back to it. Make sure everybody hit the like button. Resume.
No,
Right
she
now.
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying that by saying
exhibit.
that she could
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of
During,
speech.
okay, so what is
All right?
it implying to? What would that be implying to?
As
How would
attorney-
anyone?
all
How
right,
would
I'm
anyone in
moving
my
on
position?
because you're not
How
providing me
would-
with any
how would
legal
any-
basis.
I didn't even
for
finish.
me to.
You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that. You didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wouldn't get to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you open the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking
no-
about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I had
this
done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down and
I don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said for the trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come at
not.
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it relates
asking
to
me
other
to do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics, is my first question.
Okay, why was it an issue with me bringing it
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I don't
a yes or no.
I don't like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
Sit down. I don't care if you don't like my tone. You've been pushing my buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to
now.
each other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
gonna
to
do that.
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to
everyone.
answer if I don't understand? And I don't agree to a stop. There's been a lot of suffering involved in this incident. A lot. Obviously, with the families, with the community, and even the alleged defendant's family as well. There's been a lot of suffering. A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality. Keep in mind. The power that you have. I believe that shouldn't escape your knowledge. This has been a long process for everybody. And what I believe is when it's time for you to make your decision. All of you. I believe that. And I pray that it's the right decision. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one.
Okay, Surat says there's two sides to every story. Well, we're going by the story of what you did and what's on videotape, the clips. That's what the side that we're going by. That's facts right there. This is not he say, she say. This is facts. This man is a clown, and we're supposed to feel sorry for you? Everybody put out the violins. Violins for Surat. Let's get back to it.
One side told of this story. And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about. Thank you.
Thank you, sir.
Oh, Surat's all upset. He feels sad. Can someone pass him a tissue? He needs another tissue. You have one? Someone pass him another tissue. Resume. Hey, you see the guy in the back? The brother in the back? Yeah. You see him in the back? He's supposed to be a big time Surat supporter. Like I said before, someone had emailed, not the email, left a message, whatever. And they said that, they wanted me to do commentary on this person here. They sent me a link to a video. I can't find it, but I'm not going to do commentary because it's somebody else's, whatever video. But I guess he's a supporter of Surat. I mean, hey, each his own. You can support whoever you want. It's on you. But let's go back to Surat. Look at him. Oh, he feeling sad. Somebody hand him a tissue and some violins. Well, how do you think these other people feel? Let's get into it. You try to run her over. What about her? Let's talk about these 6 people that died. How their family feel. And about the people that's injured, that's suffering right now. Trying to figure out how they're going to pay medical bills and everything. Let's talk about them. Let's talk about the people that they didn't get hit by the car or nothing like that, but they're going through PTSD. Let's talk about them. No. We both feel sorry for Sewer Rat. Resume.
And do we have their writing materials available? All right, thank you. Mr. Brooks, you ready to call your first, would be your second witness, actually. You need a minute? We're going to take a short break. I'll rise for the jury, please. We'll be with you shortly. The materials that you were looking for, let us know if there's something you need in that regard. And Attorney Apper, if you could perhaps just confer with him over which witnesses are here. I'll step off the bench while you do that, and if someone can just let me know, I'll come back out in like between 5 and 10 minutes unless I'm told to come back out sooner.
Yes, Your Honor.
Thank you. Thank you, everyone. Please be seated. All right, you may call your first witness. Actually, your second witness.
The defense would like to call the plaintiff, state of Wisconsin, to the stand.
Your Honor, I object.
The objection is noted. It is sustained. Call your next witness, please.
Reason for the sustain?
Not relevant. And you haven't named a person to go along with it.
The subpoena was accepted, Your Honor.
I'll take the issue up outside the presence of the jury if necessary. Call your next witness, please.
Well, I would like to make an oral change motion to dismiss for failure to appear by the plaintiff and for failure to state a claim from which relief can be granted.
I will take that up outside the presence of the jury. Next witness, please.
So is the state not present?
Mr. Brooks, I'm not going to address that any further while the jury's present. I'll take that up outside their presence. Call your next witness, please.
The defense calls Nicholas Kirby.
All right. Nicholas Kirby. Is that a witness who's in the hallway? Do we know?
I don't believe in the hallway, but we will have him brought over, Your Honor.
All right, thank you. It'll be just a moment or two while we wait for that witness to come into the courtroom. Now, we're at the end of the third week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How
You're
can
not
I
gonna
be
hold it
prepared
up.
for? I'm not. So the witness is just supposed to get up there and just. I'm just like,
I'm
yeah.
not gonna have this commentary, okay? I'm done. The jury's coming out. Be prepared to call
So
one
that's
of the
a
three.
rush to judgment.
That is not a rush to judgment.
It is a rush
Again,
to
I'm done.
judgment.
The jury's
It's
coming
clearly
in.
a rush to judgment if I'm telling you that I don't have the
No,
file.
in
How
my
am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these
Which
statements
is a
made
rush to
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant.
Mr. Brooks?
You're supposed to be able to answer simple questions.
Mr. Brooks.
If I'm saying I have to bring
Call
it to
your
your
next
attention,
witness, please. That's the stage that
I have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you to please, I'm asking you to please
And
stop.
I'm asking you,
because
can
we
we
have the
address-
jury present.
I'm asking
and
you-
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said, that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter-
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
for the
yourself are
third
on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
To-
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going
I
to take
didn't-
testimony right now. Call your next
I merely
witness.
seek to put you on notice, on the record, for something that needs to be brought to your attention
And
and
I
to the
will-
court's attention.
And I will address it at
That's
the
what
next
I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment
There is
here,
a rush
sir.
to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your...
8:37.
Sorry, 8:37, you're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next
We
witness,
had a
please.
legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying the
onset-
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
can you deny
please,
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
Call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this every day.
Everyone is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to.
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks.
Do I not have your oath of office?
Under
3 of them?
90611, this court has the authority, as you know.
Do I not have,
Call.
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three of your
you are
oaths
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're doing this.
Listen,
We
Your
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this moment.
is this not your
and
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I
Call
object to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And I,
This is him gaslighting the judge. And basically he's trying to prove it's not true, but he's trying to prove that she's incompetent as a judge. That's what he's trying to do right now. This is what these sociopaths do. And he's not saying, now you're trying to say that this judge is incompetent. She doesn't know what she's doing as a judge. Really? Really, sewer rat? You... Resume.
I want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of
Mr.
the charges
Brooks,
against me. I don't even understand that part
I
of it. I
understand
haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will take-
I'm not attempting to
Mr. Brooks,
be disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to without having that letter.
So
The
what
state
about-
has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So, I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I gotta say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes,
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
because
you try to
it's
go
not a tactic.
off
It's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe it's.
I didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told you she was when we met.
interrupting.
We can ask
He's-
that question
he is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he
Don't
can
sit
show
here and try
it
to
is
think he knows what's
inadmissible,
going
he will
on.
not be questioned. And under 906.11, I will
Then you gonna
declare
talk
the
about where my
cross-examination
kids live. You don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time when
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that? Want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
How are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to...
It's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a foundation
All of a sudden, the
with
state
these
don't
witnesses.
got. All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Yeah,
fact.
I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
I'm far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe.
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
Well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury
Come on,
brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
There's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue.
I have to say, ladies and gentlemen, this one was hilarious. With him building up boxes as a fort. You know, this was insane. This was insane. I couldn't even believe this, what he was doing. But we shouldn't be surprised, ladies and gentlemen, right? With sociopath and narcissists. Share your thoughts and opinions in the comment section. Make sure you hit the like button and share the video out to others. And feel free to check out some of my past commentary. Some of my old commentary. Check out my playlist. I have some awesome playlists. All right, let's get back to it.
Continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that. Oh, you don't? I changed, hold on. 76, the 76 count, just want to make, it says near Frame Park, so it is in there, but that was just one question I had. All right. So state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them. Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom. I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling. Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? Did you see headphones? You can see everything. You can see boxes, but do you see headphones?
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is it?
Yeah, I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image of sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
It's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others. Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if appropriate.
It's gonna be a whole lot of objection then because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though you know I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent, without me. I'm telling you I don't understand, and you still make a decision determining my life.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy, civility, the rules of evidence, and
don't try to come
the
with
rules
those
of
slick
procedure?
words. Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to preserve the integrity.
You've been slick. You've been slick.
All right. I'm going to mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful. I need to go over these. All right, I'm muting him because I need to go over these important issues that have been raised by the state. So as far as the... All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you. It's not just a book, it's the book.
Can't disagree with you there, sir.
Yeah. How many people actually live by it, though? Anyway.
Sir, I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
Then you'll forfeit your right to give one, sir, because as
you can't force me. You can't force me not. What type of court is this where you can say you're going to force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
Sir, if you choose not to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon. I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake. We will need a comfort break. But you should be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately pages. We can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws if they don't agree.
You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear under the law.
I can raise what I want to raise. And you can't, so you added these jury instructions at the last minute, then you should have never approved them from the get-go, because I never approved them. I told you I didn't understand them at all whatsoever, and you still passed it.
Sir, if you understand jury nullification, you understand jury instructions. It's clear to me you've done your homework.
What you talking about? I don't care what you're talking about. I'm going to let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show me.
All right, I'm going to mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during.
Surratt is mad. He mad. For what? 'Cause all about you? Really, sir? Really? Resume.
During his closing arguments. He does not have an unfettered right to say whatever he wants or how he wants. If he is going to be adamant about defying the court's rules, which I will tell him in part what they are today, and I will work on that as we break and have a very clear advisement for him tomorrow morning, he may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I will need a very clear pledge by him that he will follow the rulings that I make as it relates to the closing arguments. He cannot raise jury nullification. He cannot raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the facts based upon his theory, based upon the evidence that's been presented, and those are the bounds. If he's going to, I can only imagine there may be some objections by the state. If there is an objection, I expect that he will stop and wait for this court to rule on the objection. I expect that if I sustain an objection, that he will honor it. And if he can't pledge to follow these very simple rules of courtesy and decorum that are consistent with the rules of procedure and the rules of evidence, then he will be in that other courtroom for his closing argument, so that I can exercise mute, frankly, to protect how he looks to that jury. Because that is the balancing that I am tasked with tomorrow, is to ensure that this jury makes a determination based upon the evidence and the law.
Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name, it's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry, you're
Ooh, I have to give her credit. This prosecutor is phenomenal. You go, girl. She broke it down. Resume.
objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have
Your
an
Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Mr. Brooks, my name is Jason Peckloff, and I'm with the Catholic Community of Waukesha. I was one of the victims you hit with the SUV you were driving on November 21st. What you did to my Catholic community and to the city of Waukesha show that you had no regard for life. What makes it more disappointing that you have shown no remorse for what you have done. While you're sitting in prison, I want you to reflect what you have done. I want you to reflect that you nearly took my life. I almost lost the chance to see my wife and kids again. I may have never had the chance to love or hug them again. You intentionally harmed my community, whether it was physical or psychological. You stole our innocence that day. Before that tragedy you created, it was a beautiful day we all experienced and never thought an evil thing like this could ever happen at a parade. My friend, myself, and the Waukesha Catholic community were asking parishioners and their families to participate in this parade. Imagine the guilt we must all bear for the rest of our lives. Because of your actions, I was out of work for about 6 weeks. Then I had to go back part-time because of my sustained injuries. Because of your actions, the multiple lacerations you created leaked out of the bandages and onto my bed, comforter, and sheets. What an awful visual to have. Because of your actions, I could have lost my foot. Thank God my nurse friend was checking on me. Because of your actions, my wife cannot get the images out of her mind of what you have done. You have forever scarred her. Because of your actions, my wife had to hand over my children to our community friends to check on my lifeless body. Because of your actions, my children, 4 and 6 at the time, had to go with a grieving friend to find her own child that was in lockdown. It took a while for them to be reunited. Because of your actions, my children are scared to death when they had to cross the same street you drove down. They were bawling and begging me not to cross the street. Because of your actions, I need to reassure my children that it is safe at parades. Not sure they ever feel 100% safe. Because of your actions, not all people in our community are ready to go back to the parades. Again, you stole that innocence from them. Because of your actions, my children are scared of sirens. Because of your actions, they were scared of red SUVs every time they saw one. They cried and hid. Because of your actions, I walked into the entrance of my children's school and felt like a triage unit. I saw children on crutches and a walker. What an awful image to be burned into my memory. Because of your actions, I feel terrible. I could not help my community and the city by testifying during the trial. Your cowardly actions did this. Your actions forced my family to seek out therapy and resolve in their minds what happened. Your actions made us second guess what we did that day. What could we have done differently? During this trial, you show no remorse. It makes you look like a monster. During the trial, you show little regard and respect to the court. It makes you look disrespectful. During the trial, you treated multiple witnesses terribly. You were trying to twist the words of our pastor, who is a man of the cloth. You made a comment to a witness you injured that he was walking fine now. It makes you a callous jerk. Despite what you have done to my community, I forgive you. Forgiveness does not remove the need for justice. Justice must be served and you must go to prison. My prayer is that forgiveness will heal your wounds and the wounds for the city. Thank you.
Thank you, sir.
Many people and organizations stepped up to help me. Family, friends, neighbors, co-workers, first responders, Aurora, doctors, nurses, my church family, the Catholic Community of Waukesha, Knights of Columbus, AOH, United for Waukesha Community Fund, Catholic Charities, and so many strangers offered support and prayers. The vast majority of people are good. That said, then there is Mr. Brooks. He is a unique individual. Who can have a clear conscience after running over kids like speed bumps and killing 6 people? I would suggest someone without a conscience. He doesn't ask for forgiveness. He doesn't admit to doing anything wrong. It is never his fault. When he slapped a woman, it was her fault because she made him mad. I believe if he made it home that night with the red SUV, he would have told his mom the damage wasn't his fault. He was in a hurry and people didn't get out of his way. Some crazy, old, fat, gray-hair guy body slammed his hood. I didn't watch all the trial, but the parts I saw showed Mr. Brooks had a lack of empathy for his victims or remorse for his actions. The only regrets he seemed to have is that he was caught and the impact on his own life. Free, he would probably not drive through another parade, but chances are someone so self-centered as Mr. Brooks will hurt other people again. The only life he seems to value is his own. I don't believe that Mr. Brooks will think about me or any of his victims ever. The feeling is mutual. I really don't think much about him now, but when the prison door closes on this felon, I won't think about him again. I do hope Mr. Brooks will use the Bible for more than a courtroom prop. He may want to start with the basics that I know his family had taught him, thou shalt not kill, but then he might want to read Galatians chapter 6, verse 7. Your Honor, I hope you give him the time to read and study the Bible. Mr. Brooks did everything he could to try to make the trial a circus. It is not a circus. It's not even about Mr. Brooks. Today, the court will hear what the trial is about, the victims. And as former victim ZZ, I would ask the court for a sentence that keeps the defendant, Darrell E. Brooks Jr., away from society forever. Thank you.
Well, order of the court, if I may, really quick, pertaining to the last speaker, I have an issue with, if it pleases the court, we can address it later, or if you want to address it now, I'm not sure.
These are sentencing remarks. I'm not going to interrupt those sentencing remarks to have you address him individually.
No, I'm not talking about addressing him individually.
Mr. Brooks, we're going to continue. I'm not sure what you could possibly bring to the court's attention about a speaker who's already made a statement.
A very valid issue that I can bring to the
You
court.
can put it in writing, sir, while you're sitting there, and if it's something I need to address, I will. But I'm not going to disrupt what's happening right now to address that. You need to put it in writing. All right, go ahead, Ms.
So, put it in writing that
Mr. Brooks, please put it in writing.
that's
If you
the
need some
same,
paper,
that's the
then
same person you had that worked with the father of, right?
go ahead, Ms. Dunn.
Like I said,
The
the same
record speaks
person.
for itself. All of those issues were previously put on the record. There's no need for you to make any
That is him
commentary
though,
about
right?
it.
You did work with his father though, right?
Mr. Brooks, stop. If you interrupt me again, you're gonna risk going into the other courtroom. I'm not gonna have
So
you
you gonna hold me in
degrade
contempt?
the integrity of these proceedings.
I'm not
and the
attempting to
solemnity
cause
of
a
what's going on
controversy. I
right
just
now
wanted to know
by
that.
once again trying to derail what's happening and
And
take
you
the
always
focus
talk
off of.
about somebody trying to derail something as if that was the plan, like somebody coming here
Mr.
to
Brooks, I'm
derail
advising
something.
you to be quiet or I will clear this courtroom, and under Illinois versus Allen, you will lose your right to be present while the remainder of these individuals give their statements.
Okay, well, come on with it.
Once they start, I expect you to be
Come
quiet.
on with it, because that's what you've been waiting to do the whole time.
Piece of shit. Listen up and listen what she has to say.
All right.
God damn.
Sir, you're gonna have to be removed. I'm sorry. I can't tolerate that from anyone. Mr. Brooks, my admonishment to you is the next person's going to get up and they're going to start their statement. And if
Okay, yeah, but you
interrupt-
made it seem like I'm trying to purposely interrupt that.
Mr. Brooks,
And I don't think
I'm
that's
turning
fair
to
to do
them.
that.
please be quiet.
Okay. Yeah, I still have the First Amendment right to be heard and to speak. I still have that right.
Mr. Brooks, this is a sentencing hearing.
I don't
The
care
trial
what it is. You're not
All
going to
right.
continue.
He is arguing
You're
with
not-
me. He is now forfeited.
You're not
his
gonna
right to be
continue-
present.
you're
Everyone
not
is to
gonna
clear the courtroom
continue-
while he's moved to the next courtroom, and I'll make the appropriate findings when I'm able to do that
So
without
can I get a
interruption.
finding of fact? Can I get a
I'm
legal
stepping
finding
off
of
the
fact?
bench.
Because I don't
We're in
agree to a
recess while that
stopper.
happens.
I think he was able to do it. I just don't think he wanted to. I just think this is all part of his charade. This referring to himself in the third person, trying to distract him or detract himself, I should say, from the events, taking absolutely no responsibility. It's the act of a narcissistic coward. Those words have been used here today, and nothing could be further from the truth. He is a coward. He ran like a scared little chicken from this parade, trying to slither away in the dark of night, but only to stop long enough and try and take advantage of good citizens that would help him. He calls and lies to his mom, right? Get me an Uber. I can't get into it. He lies to the officers repeatedly. We saw the time of his arrest. We heard the testimony from Daniel Ryder, a good man with good intentions and a good heart who took this murderer into his home and held him there long enough for the police to come and take him away without any knowledge whatsoever of what had gone on. He takes advantage of everyone. He's extremely manipulative. He absolutely thinks he's in control of everything, when in fact, as he sits here in custody, he's in control of nothing except for his own behavior.
Mr. Brooks, be quiet.
Except
I'm
for
not
his
going to sit here and be disrespected.
Mr. Brooks, be quiet.
I'm not going to
You'll
sit
have
here
your
and be
opportunity.
disrespected.
These are sentencing arguments and they can make them.
So I could do the same thing?
Mr. Brooks, there's nothing disrespectful. They're doing it in
Yes,
a
it is.
respectful
Okay,
way.
call me out of my name again.
Go ahead, Attorney Opera.
Judge, these are
Sorat, you said call me out my name again. What are you gonna do? What are you gonna do? Are you serious, dude? Oh my gosh. You go, girl. You finish prosecution. Go ahead. Say what you have to say. He have to shut up and listen.
are the facts. You heard from so many of these parents and so many of the people that were there of that fight or flight, right, that kicked in. He ran.
This needs to be said. What happened on November 21st, 2021 was not an attack. It was not planned, plotted. When you constantly hear that perpetuated, constantly pushed, constantly pushed, constantly pushed, you wonder why. Why? This was not an attack. This was not an intentional act. No matter how many times you say it over and over, it was not. I know this is being live streamed. I believe even in other countries. I've gotten some mail from Germany, Belgium, a lot of it hate mail, which doesn't. I stopped reading it months ago, so it doesn't really affect me. It's irrelevant. I do want to say something to everybody watching, as far as those who take the time, spend the energy and money to write and spew hate, not just against myself, but my family, my children. I have no value in anything that you say. It doesn't bother me. It doesn't affect me. Keep up the bad work. To everyone else, the people that have sent letters of support, I thank you for that, because it's not an easy thing to show love and support to someone who's the most hated man on the planet at this point right now in time. It's not easy. It takes a lot of courage to do that. And I thank you for that. My family thanks you for that. I won't ever be able to wrap my head around why you did things the way you did it. Made reference to this being an open and shut case. Yet you needed a whole team to prosecute an open and shut case, as you say. And again, no disrespect to Attorney Basie, Attorney Whitchild. I feel like they was the reasons why your case had any strong points, not from you. "31 years, you said, well, yeah, you did say.
The prosecution, you see that face? They just like, really, really, sir, really, sewer rat. He's a fool. Okay, resume.
31 years that you've done this. 31 years. believe you're that bright. I won't.
Okay, ladies and gentlemen, that's the end of Surat. You know what? This man is just a piece of work. Yep, he is. All right, let me just share one thing because I want to have this closing on one thing before him. Just give me a second. Look at Surat when he was a baby. Surat with little Mickey Mouse ears with grandma. With grandma. All right, give me just a second here. Alright, I have to end with my favorite video. Yes, I have to close with my favorite one. I just love this video so much. I love this one. So we're going to close out on this one. Alright, so, ladies and gentlemen, that's it. That's just all. So I just wanted to do the recap of, you know, the madness of him in the courtroom. You know, I just hope people learn about a lot of his behaviors, you know, sociopathic behaviors. Sociopath and narcissist. They don't care about nobody. It's all about them. They don't have no empathy at all. At all. They don't care. It's about them. And this man has got away with so much in his life for years. For years. And I have to say, he has enablers, like his enabler right here, his family, grandma and mama. They've all been enablers, right? And even the court system has been enablers with him too. The court system. Because if he wasn't let out before, this wouldn't have happened. When somebody has a, you know, criminal history like him, they will never change. When the person reaches a certain age and have this criminal history, they're not going to change. This is embedded in them. This is who they are, and this is how they're going to always be. But you know what? God put a stop to it. You will never be able to hurt anybody else. You will never be able to control, manipulate women and abuse them, or hurt any innocent people. People's out there in the Christmas parade having a good time enjoying themselves for the holidays, and here you come. Are you kidding me? And your family's gonna be enablers? Really? No, it doesn't work that way. Alright, so we're gonna end off my favorite video. I just love this clip. I love it so much. Alright, so everybody make sure you hit the like button. Thank you so much for watching. I appreciate it. Check out some of my past commentary. And stay tuned for some more of my commentary, because 2023 is coming, and I'm going to have a lot of commentary on dating, love, relationship, give advice. And if you need to reach out to me, look in my description. You can find my email address and reach out to me for coaching. If you have any views requests for the new year, I'll be doing some animation on dating, love, relationships, and I'm also giving dating advice, and I'm going to also be doing some trials and just basically focus on narcissists and sociopaths and their behavior, because I need people to watch out for these signs, because the more you watch out for the red flags, the more that it will be like a shield over you, so you won't have to be bothered with these people, because all they do is come into your life to use and abuse you. So you have to be careful. And it comes in all nationalities, all sexes, all ages, all sizes. They out there. Okay, male, female, children. You know, mommy and daddy could lay down and have Satan Jr. It is what it is. I hate to say. And you know what? That's what my channel is about, focusing on all these different areas. And hopefully it's helpful to you. And if it is helpful to you, share it out with others. Alright, let's close out to this last video, ladies and gentlemen. And everybody have a great one and a blessed one. And remember, date smart, not thirsty. Let's get it.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. Weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do homicide while using a dangerous weapon. Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And it should state as to count 2 it was